Hello, everyone. We're going to continue with part two. So, right now we're at Mr. Justice Marshall concurring. These three cases present the question whether the death penalty is a cruel and unusual punishment prohibited by the Eighth Amendment to the United States Constitution. In number 69, 5003, Furman was convicted of murder for shooting the father of five children when he discovered that Furman had broken into his home early one morning, and numbers 69, 5030 and 69, 5031 involve state convictions for forcible rape. Jackson was found guilty of rape during the course of a robbery in the victim's home. The rape was accomplished as he held the pointed end of scissors at the victim's throat. Branch also was convicted of a rape committed in the victim's home. No weapon was utilized, but physical force and threats of physical force were employed. The criminal acts with which we are confronted are ugly, vicious, reprehensible acts. Their sheer brutality cannot and should not be minimized. But we are not called upon to condone the penalized conduct. We are asked only to examine the penalty imposed on each of the petitioners and to determine whether or not it violates the Eighth Amendment. The question then is not whether we condone rape or murder, for surely we do not. It is whether capital punishment is a punishment no longer consistent with our own self-respect, and therefore violative of the Eighth Amendment. The elasticity of the constitutional provision under consideration presents dangers of too little or too much self-restraint. Hence, we must proceed with caution to answer the question presented. By first examining the historical derivation of the Eighth Amendment and the construction given it in the past by this court, and then exploring the history and attributes of capital punishment in this country, we can answer the question presented with objectivity and a proper measure of self-restraint. Candor is critical to such an inquiry. All relevant material must be marshaled and sorted and forthrightly examined. We must not only be precise as to the standards of judgment that we are utilizing, but exacting in examining the relevant material in light of those standards. Candor compels me to confess that I am not oblivious to the fact that this is truly a matter of life and death. Not only does it involve the lives of these three petitioners, but those of almost 600 other condemned men and women in this country currently awaiting execution. While this fact cannot affect our ultimate decision, it necessitates that the decision be free from any possibility of error. The Eighth Amendment's ban against cruel and unusual punishments derives from English law. In 1583, John Whitgift, Archbishop of Canterbury, turned the High Commission into a permanent ecclesiastical court, and the commission began to use torture to extract confessions from persons suspected of various offenses. Sir Robert Peel protested that cruel and barbarous torture violated Magna Carta, but his protests were made in vain. Cruel punishments were not confined to those accused of crimes, but were notoriously applied with even greater relish to those who were convicted. Blackstone described in ghastly detail the myriad of inhumane forms of punishment imposed on persons found guilty of any of a large number of offenses. Death, of course, was the usual result. The treason trials of 1685, the bloody assizes, which followed an abortive rebellion by the Duke of Monmouth, marked the culmination of the parade of horrors, and most historians believe that it was this event that finally spurred the adoption of the English Bill of Rights, containing the progenitor of our prohibition against cruel and unusual punishments. The conduct of Lord Chief Justice Jeffreys at those trials has been described as an insane lust for cruelty, which was stimulated by orders from the King, James II. The assizes received wide publicity from Puritan pamphleteers and doubtless had some influence on the adoption of a cruel and unusual punishments clause. But the legislative history of the English Bill of Rights of 1689 indicates that the assizes may not have been as critical to the adoption of the clause as is widely thought. After William and Mary of Orange crossed the Channel to invade England, James II fled. Parliament was summoned into session, and a committee was appointed to draft general statements containing such things as are absolutely necessary to be considered for the better securing of our religion, laws, and liberties. An initial draft of the Bill of Rights prohibited illegal punishments, but a later draft referred to the infliction by James II of illegal and cruel punishments, and declared cruel and unusual punishments to be prohibited. The use of the word unusual in the final draft appears to be inadvertent. This legislative history has led at least one legal historian to conclude that the Cruel and Unusual Punishments Clause of the Bill of Rights of 1689 was first an objection to the imposition of punishments that were unauthorized by statute and outside the jurisdiction of the sentencing court, and second, a reiteration of the English policy against disproportionate penalties, and not primarily a reaction to the torture of the High Commission, harsh sentences, or the assizes. Whether the English Bill of Rights prohibition against cruel and unusual punishments is properly read as a response to excessive or illegal punishments, as a reaction to barbaric and objectionable modes of punishment, or as both, there is no doubt whatever that in borrowing the language and in including it in the Eighth Amendment, our founding fathers intended to outlaw torture and other cruel punishments. The precise language used in the Eighth Amendment first appeared in America on June 12, 1776, in Virginia's Declaration of Rights, subsection 9 of which read, that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This language is drawn verbatim from the English Bill of Rights of 1689. Other states adopted similar clauses, and there is evidence in the debates of the various state conventions that were called upon to ratify the Constitution of great concern for the omission of any prohibition against torture or other cruel punishments. The Virginia Convention offers some clues as to what the Founding Fathers had in mind in prohibiting cruel and unusual punishments. At one point, George Mason advocated the adoption of a Bill of Rights, and Patrick Henry concurred, stating, "By this Constitution, some of the best barriers of human rights are thrown away. Is there not an additional reason to have a Bill of Rights? Congress, from their general powers, may fully go into business of human legislation. They may legislate in criminal cases from treason to the lowest offense, petty larceny. They may define crimes and prescribe punishments. In the definition of crimes, I trust they will be directed by what wise representatives ought to be governed by. But when we come to punishments, no latitude ought to be left, nor dependence put on the virtue of representatives. What says our Bill of Rights? That excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Are you not, therefore, now calling on those gentlemen who are to compose Congress to prescribe trials and define punishments without this control? Will they find sentiments there similar to this Bill of Rights? You let them loose, you do more, you depart from the genius of your country. In this business of legislation, your members of Congress will loose the restriction of not imposing excessive fines, demanding excessive bail, and inflicting cruel and unusual punishments. These are prohibited by your Declaration of Rights. What has distinguished our ancestors? That they would not admit of tortures or cruel and barbarous punishment. That they would not admit of tortures or cruel and barbarous punishment. But Congress may introduce the practice of the civil law, in preference to that of the common law. They may introduce the practice of France, Spain, and Germany, of torturing to extort a confession of the crime. They will say that they might as well draw examples from those countries as from Great Britain, and they will tell you that there is such a necessity of strengthening the arm of government, that they must have a criminal equity and extort confession by torture in order to punish with still more relentless severity. We are then lost and undone. Henry's statement indicates that he wished to ensure that relentless severity would be prohibited by the Constitution. Other expressions with respect to the proposed Eighth Amendment by members of the First Congress indicate that they shared Henry's view of the need for and purpose of the Cruel and Unusual Punishments Clause. Thus, the history of the clause clearly establishes that it was intended to prohibit cruel punishments. We must now turn to the case law to discover the manner in which courts have given meaning to the term cruel. This court did not squarely face the task of interpreting the cruel and unusual punishments language for the first time until Wilkerson v. Utah, although the language received a cursory examination in several prior cases. In Wilkerson, the court unanimously upheld a sentence of public execution by shooting imposed pursuant to a conviction for premeditated murder. In his opinion for the court, Mr. Justice Clifford wrote, "Difficulty would attend the effort to define with exactness the extent of the constitutional provision which provides that cruel and unusual punishments shall not be inflicted, but it is safe to affirm that punishments of torture and all others in the same line of unnecessary cruelty are forbidden by the amendment to the Constitution." Thus, the court found that unnecessary cruelty was no more permissible than torture. To determine whether the punishment under attack was unnecessarily cruel, the court examined the history of the Utah Territory and the then current writings on capital punishment. and compared this nation's practices with those of other countries. It is apparent that the court felt it could not dispose of the question simply by referring to traditional practices. Instead, it felt bound to examine developing thought. 11 years passed before the court again faced a challenge to a specific punishment under the Eighth Amendment. In the case of In re Kemmler, Chief Justice Fuller wrote an opinion for a unanimous court upholding electrocution as a permissible mode of punishment. While the court ostensibly held that the Eighth Amendment did not apply to the states, it is very apparent that the nature of the punishment involved was examined under the Due Process Clause of the 14th Amendment. The court held that the punishment was not objectionable. Today, Kemmler stands primarily for the proposition that a punishment is not necessarily unconstitutional simply because it is unusual, so long as the legislature has a humane purpose in selecting it. 2 years later, in O'Neill v. Vermont, the court reaffirmed that the Eighth Amendment was not applicable to the states. O'Neill was found guilty on 307 counts of selling liquor in violation of Vermont law, a fine of $6,140, $20 for each offense, and the costs of prosecution, $497.96, were imposed. O'Neill was committed to prison until the fine and the costs were paid, and the court provided that if they were not paid before the specified date, O'Neill was to be confined in the House of Corrections for 19,914 days, approximately 54 years, at hard labor. 3 justices, Field, Harlan, and Brewer, dissented. They maintained not only that the Cruel and Unusual Punishments Clause was applicable to the states, but that in O'Neill's case it had been violated. Mr. Justice Field wrote, "That designation, cruel and unusual punishment, it is true, is usually applied to punishments which inflict torture, such as the rack, the thumbscrew, the iron boot, the stretching of limbs, and the like, which are attended with acute pain and suffering. The inhibition is directed not only against punishments of the character mentioned, but against all punishments which are by their excessive length or severity are greatly disproportioned to the offenses charged. The whole inhibition is against that which is excessive." In Howard v. Fleming, the court, in essence, followed the approach advocated by the dissenters in O'Neill. In rejecting the claim that 10-year sentences for conspiracy to defraud were cruel and unusual, the court, per Mr. Justice Brewer, considered the nature of the crime, the purpose of the law, and the length of the sentence imposed. The court used the same approach 7 years later in the landmark case of Weems v. United States. Weems, an officer of the Bureau of Coast Guard and Transportation of the United States government of the Philippine Islands, was convicted of falsifying a public and official document. He was sentenced to 15 years incarceration at hard labor with chains on his ankles, to an unusual loss of his civil rights, and to perpetual surveillance. Called upon to determine whether this was a cruel and unusual punishment, the court found that it was. The court emphasized that the Constitution was not an ephemeral enactment or one designed to meet passing occasions. Rather, that time works change and brings into existence new conditions and purposes. The court commented that in the application of a constitution, our contemplation cannot be only of what has been, but what of may be. In striking down the penalty imposed on Weems, the court examined the punishment in relation to the offense, compared the punishment to those inflicted for other crimes and to those imposed in other jurisdictions, and concluded that the punishment was excessive. Justice White and Holmes dissented and argued that the cruel and unusual prohibition was meant to prohibit only those things that were objectionable at the time the Constitution was adopted. Weems is a landmark case because it represents the first time that the court invalidated a penalty prescribed by a legislature for a particular offense. The court made it plain beyond any reasonable doubt that excessive punishments were as objectionable as those that were inherently cruel. Thus, it is apparent that the dissenters' position in O'Neill had become the opinion of the court in Weems. Weems was followed by 2 cases that added little to our knowledge of the scope of the cruel and unusual language. Batters v. United States, and United States ex rel. Milwaukee Social Democratic Publishing Company v. Burleson. Then came another landmark case in Louisiana ex rel. Francis v. Resweber. Francis had been convicted of murder and sentenced to be electrocuted. The first time the current passed through him, there was a mechanical failure and he did not die. Thereafter, Francis sought to prevent a second electrocution on the ground that it would be a cruel and unusual punishment. 8 members of the court assumed the applicability of the Eighth Amendment to the states. The court was virtually unanimous in agreeing that the traditional humanity of modern Anglo-American law forbids the infliction of unnecessary pain, but split 5-4 on whether Francis would, under the circumstances, be forced to undergo any excessive pain. 5 members of the court treated the case like in Kemmler, and held that the legislature adopted electrocution for a humane purpose, and that its will should not be thwarted because, in its desire to reduce pain and suffering in most cases, it may have inadvertently increased suffering in one particular case. The 4 dissenters felt that the case should be remanded for further facts. As in Weems, the court was concerned with excessive punishments. Resweber is perhaps most significant because the analysis of cruel and unusual punishment questions first advocated by the dissenters in O'Neill was at last firmly entrenched in the minds of an entire court. Trop v. Dulles marked the next major cruel and unusual punishment case in this court. Trop, a native-born American, was declared to have lost his citizenship by reason of a conviction by court-martial for wartime desertion. Writing for himself and Justice Black, Douglas, and Whitaker, Chief Justice Warren concluded that loss of citizenship amounted to a cruel and unusual punishment that violated the Eighth Amendment. Emphasizing the flexibility inherent in the words cruel and unusual, the Chief Justice wrote that the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. His approach to the problem was that utilized by the court in Weems. He scrutinized the severity of the penalty in relation to the offense, examined the practices of other civilized nations of the world, and concluded that involuntary statelessness was an excessive and therefore an unconstitutional punishment. Justice Frankfurter, dissenting, urged that expatriation was not punishment, and that even if it were, it was not excessive. While he criticized the conclusion arrived at by the Chief Justice, his approach to the Eighth Amendment question was identical. Whereas in Trop, a majority of the court failed to agree on whether loss of citizenship was a cruel and unusual punishment, 4 years later a majority did agree in Robinson v. California that a sentence of 90 days imprisonment for violation of a California statute making it a crime to be addicted to the use of narcotics was cruel and unusual. Mr. Justice Stewart, writing the opinion of the court, reiterated what the court had said in Weems, and what Chief Justice Warren wrote in Trop, that the cruel and unusual punishment clause was not a static concept, but one that must be continually re-examined in the light of contemporary human knowledge. The fact that the penalty under attack was only 90 days evidences the fact that the penalty under attack was only 90 days evidences the court's willingness to carefully examine the possible excessiveness of punishment in a given case, even where it was involved in it, even where what is involved is a penalty that is familiar and widely accepted. We distinguished Robinson in Powell v. Texas, where we sustained a conviction for drunkenness in a public place and a fine of $20. 4 justices dissented on the ground that Robinson was controlling. The analysis in both cases was the same. Only the conclusion as to whether or not the punishment was excessive differed. Powell marked the last time prior to today's decision that the court has had occasion to construe the meaning of the term cruel and unusual punishment. Several principles emerge from these prior cases and serve as a beacon to an enlightened decision in the instant cases. Perhaps the most important principle in analyzing cruel and unusual punishment questions is one that is reiterated again and again in the prior opinions of the court, i.e. the cruel and unusual language must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Thus, a penalty that was permissible at one time in our nation's history is not necessarily permissible today. The fact, therefore, that the court or individual justices may have in the past expressed an opinion that the death penalty is constitutional is not now binding on us. A fair reading of Wilkerson v. Utah in Kemmler and Louisiana ex rel. Francis v. Resweber would certainly indicate an acceptance sub silento of capital punishment as constitutionally permissible. Several justices have also expressed their individual opinions that the death penalty is constitutional. Yet some of these same justices and others have at times expressed concern over capital punishment. There is no holding directly in point, and the very nature of the Eighth Amendment would dictate that unless a very recent decision existed, stare decisis would bow to changing values, and the question of the constitutionality of capital punishment at a given moment in history would remain open. Faced with an open question, we must establish our standards for decision. The decisions discussed in the previous section imply that a punishment may be deemed cruel and unusual for any one of four distinct reasons. First, there are certain punishments that inherently involve so much physical pain and suffering that civilized people cannot tolerate them. For example, use of the rack, the thumbscrew, and other modes of torture. Regardless of public sentiment with respect to imposition of one of these punishments in a particular case or at any one moment in history, the Constitution prohibits it. These are punishments that have been barred since the adoption of the Bill of Rights. Second, there are punishments that are unusual, signifying that they were previously unknown as penalties for a given offense. If these punishments are intended to serve a humane purpose, they may be constitutionally permissible. Prior decisions leave open the question of just how much the word unusual adds to the word cruel. I have previously indicated that the use of the word unusual in the English Bill of Rights of 1689 was inadvertent, and there is nothing in the history of the Eighth Amendment to give flesh to its intended meaning. In light of the meager history that does exist, one would suppose that an innovative punishment would probably be constitutional if no more cruel than the punishment which it superseded. We need not decide this question here. However, for capital punishment is certainly not a recent phenomenon. Third, a penalty may be cruel and unusual because it is excessive and serves no valid legislative purpose. The decisions previously discussed are replete with assertions that one of the primary functions of the Cruel and Unusual Punishments Clause is to prevent excessive or unnecessary penalties. These punishments are unconstitutional even though popular sentiment may favor them. Both the Chief Justice and Mr. Justice Powell seek to ignore or to minimize this aspect of the court's prior decisions. But since Mr. Justice Field first suggested that the whole inhibition of the prohibition against cruel and unusual punishments is against that which is excessive, this court has steadfastly maintained that a penalty is unconstitutional whenever it is unnecessarily harsh or cruel. This is what the founding fathers of this country intended. This is what their fellow citizens believed the Eighth Amendment provided, and this was the basis for our decision in Robinson v. California, for the plurality opinion by Mr. Chief Justice Warren in Trop v. Dulles, and for the court's decision in Weems v. United States. It should also be noted that the cruel and unusual language of the Eighth Amendment immediately follows language that prohibits excessive bail and excessive fines. The entire thrust of the Eighth Amendment is, in short, against that which is excessive. Fourth, where a punishment is not excessive and serves a valid legislative purpose, it still may be invalid if popular sentiment abhors it. For example, if the evidence clearly demonstrated that capital punishment served valid legislative purposes, such punishment would nevertheless be unconstitutional if citizens found it to be morally unacceptable. A general abhorrence on the part of the public would, in effect, equate a modern punishment with those barred since the adoption of the Eighth Amendment. There are no prior cases in this court striking down a penalty on this ground, but the very notion of changing values requires that we recognize its existence. It is immediately obvious, then, that since capital punishment is not a recent phenomenon, if it violates the Constitution, it does so because it is excessive or unnecessary, or because it is abhorrent or to currently existing moral values. We must proceed to the history of capital punishment in the United States. Capital punishment has been used to penalize various forms of conduct by members of society since the beginnings of civilization. Its precise origins are difficult to perceive, but there is some evidence that its roots lie in violent retaliation by members of a tribe or group, or by the tribe or group itself, against persons committing hostile acts toward group members. Thus, infliction of death as a penalty for objectionable conduct appears to have its beginnings in private vengeance. As individuals gradually ceded their personal prerogatives to a sovereign power, the sovereign accepted the authority to punish wrongdoing as part of its divine right to rule. Individual vengeance gave way to the vengeance of the state, and capital punishment became a public function. Capital punishment worked its way into the laws of various countries, and was inflicted in a variety of macabre and horrific ways. It was during the reign of Henry II that English law first recognized that crime was more than a personal affair between the victim and the perpetrator. The early history of capital punishment in England is set forth in Magatha v. California, and need not be repeated here. By 1500, English law recognized 8 major capital crimes: treason, petty treason, killing of husband by his wife, murder, larceny, robbery, burglary, rape, and arson. Tudor and Stuart kings added many more crimes to the list of those punishable by death, and by 1688 there were nearly 50. George II added nearly 36 more, and George III increased the number by 60. By shortly after 1800, capital offenses numbered more than 200, and not only included crimes against person and property, but even some against the public peace. While England may, in retrospect, look particularly brutal, Blackstone points out that England was fairly civilized when compared to the rest of Europe. Capital punishment was not as common a penalty in the American colonies. The capital laws of New England, dating from 1636, were drawn by the Massachusetts Bay Colony and are the first written expression of capital offenses known to exist in this country. These laws make the following crimes capital offenses: idolatry, witchcraft, blasphemy, murder, assault in sudden anger, sodomy, buggery, adultery, statutory rape, man-stealing, perjury in a capital trial, and rebellion. Each crime is accompanied by a reference to the Old Testament to indicate its source. It is not known with any certainty exactly when, or even if, these laws were enacted as drafted, and if so, just how vigorously these laws were enforced. We do know that the other colonies had a variety of laws that spanned the spectrum of severity. By the 18th century, the list of crimes became much less theocratic and much more secular. In the average colony, there were 12 capital crimes. This was far fewer than existed in England, and part of the reason was that there was a scarcity of labor in the colonies. Still, there were many executions because, with county jails inadequate and insecure, the criminal population seemed best controlled by death, mutilation, and fines. Even in the 17th century, there was some opposition to capital punishment in some of the colonies. In his Great Act of 1682, William Penn prescribed death only for premeditated murder and treason, although his reform was not long-lived. In 1776, the Philadelphia Society for Relieving Distressed Prisoners organized, and it was followed 11 years later by the Philadelphia Society for Alleviating the Miseries of Public Prisons. These groups pressured for reform of all penal laws, including capital offenses. Dr. Benjamin Rush soon drafted America's first reasoned argument against capital punishment, entitled An Inquiry into the Effects of Public Punishments upon Criminals and upon Society. In 1793, William Bradford, the Attorney General of Pennsylvania and later Attorney General of the United States, conducted an inquiry how far the punishment of death is necessary in Pennsylvania. He concluded that it was doubtful whether capital punishment was at all necessary, and that until more information could be obtained, it should be immediately eliminated for all offenses except high treason and murder. The inquiries of Rush and Bradford and the Pennsylvania movement toward abolition of the death penalty had little immediate impact on the practices of other states. But in the early 1800s, Governors George and DeWitt Clinton and Daniel Tompkins unsuccessfully urged the New York legislature to modify or end capital punishment. During the same period, Edward Livingston, an American lawyer who later became Secretary of State and Minister to France under President Andrew Jackson, was appointed by the Louisiana legislature to draft a new penal code. At the center of his proposal was the total abolition of capital punishment. His introductory report to the system of penal law, prepared by the state of Louisiana, contained a systematic rebuttal of all arguments favoring capital punishment. Drafted in 1824, it was not published until 1833. This work was a tremendous impetus to the abolition movement for the next half-century. During the 1830s, there was a rising tide of sentiment against capital punishment. In 1834, Pennsylvania abolished public executions, and 2 years later, the report on capital punishment made to the Maine legislature was published. It led to a law that prohibited the executive from issuing a warrant for execution within 1 year after a criminal was sentenced by the courts. The totally discretionary character of the law was at odds with almost all prior practices. The Maine law resulted in little enforcement of the death penalty, which was not surprising since the legislature's idea in passing the law was the affirmative burden placed on the governor to issue a warrant 1 full year or more after a trial would be an effective deterrent to exercise of his power. The law spread throughout New England and led to Michigan's being the first state to abolish capital punishment in 1846. Anti-capital punishment feeling grew in the 1840s as the literature of the period pointed out the agony of the condemned man and expressed the philosophy that repentance atoned for the worst crimes and that true repentance derived not from fear but from harmony with nature. By 1850, societies for abolition existed in Massachusetts, New York, Pennsylvania, Tennessee, Ohio, Alabama, Louisiana, Indiana, and Iowa. New York, Massachusetts, and Pennsylvania constantly had abolition bills before their legislatures. In 1852, Rhode Island followed in the footsteps of Michigan and partially abolished capital punishment. Wisconsin totally abolished the death penalty for the following year. Those states that did not abolish the death penalty greatly reduced its scope, and few states outside the South had more than one or two capital offenses, in addition to treason and murder. But the Civil War halted much of the abolition furor. One historian has said that after the Civil War, men's finer sensibilities, which had once been revolted by the execution of a fellow being, seemed hardened and blunted. Some of the attention previously given to abolition was diverted to prison reform. An abolitionist movement still existed, however. Maine abolished the death penalty in 1876, restored it in 1883, and abolished it again in 1887. Iowa abolished capital punishment from 1872 to 1878. Colorado began an erratic period of de facto abolition and revival in 1872, and Kansas also abolished it de facto in 1872 and by law in 1907. One great success of the abolitionist movement in the period from 1830 to 1900 was almost complete elimination of mandatory capital punishment. Before the legislatures formally gave juries discretion to refrain from imposing the death penalty, the phenomenon of jury nullification, in which juries refused to convict in cases in which they believed that death was an inappropriate penalty, was experienced. Tennessee was the first state to give juries discretion, but other states quickly followed suit. Then Representative Curtis of New York introduced a federal bill that ultimately became law in 1897, which reduced the number of federal capital offenses from 60 to 3. Treason, murder, and rape, and gave the jury sentencing discretion in murder and rape cases. By 1917, 12 states had become abolitionist jurisdictions, but under the nervous tension of World War I, 4 of these states reinstituted capital punishment, and promising movements in other states came grinding to a halt. During the period following the First World War, the abolitionist movement never regained its momentum. It is not easy to ascertain why the movement lost its vigor. Certainly, much attention was diverted from penal reform during the economic crisis of the Depression and the exhausting years of struggle during World War II. Also, executions, which had once been frequent public spectacles, became infrequent private affairs. The manner of inflicting death changed, and the horrors of the punishment were, therefore, somewhat diminished in the minds of the general public. In recent years, there has been renewed interest in modifying capital punishment. New York has moved toward abolition, as have several other states. In 1967, a bill was introduced in the Senate to abolish capital punishment for all federal crimes, but it died in committee. At the present time, 41 states, the District of Columbia, and other federal jurisdictions authorize the death penalty for at least one crime. It would be fruitless to attempt here to categorize the approach to capital punishment taken by the various states. It is sufficient to note that murder is the crime most often punished by death, followed by kidnapping and treason. Rape is a capital offense in 16 states and the federal system. The foregoing history demonstrates that capital punishment was carried from Europe to America, but once here was tempered considerably. At times in our history, strong abolitionist movements have existed, but they have never been completely successful, as no more than 1/4 of the United States of the Union have at any one time abolished the death penalty. They have had partial success, however, especially in reducing the number of capital crimes, replacing mandatory death sentences with jury discretion, and developing more humane methods of conducting executions. This is where a historical foray leads. The question now to be faced is whether American society has reached a point where abolition is not dependent on a successful grassroots movement in particular jurisdictions, but is demanded by the Eighth Amendment. To answer this question, we must first examine whether or not the death penalty is today tantamount to excessive punishment. In order to assess whether or not death is an excessive or unnecessary penalty, it is necessary to consider the reasons why a legislature might select it as punishment for one or more offenses, and examine whether less severe penalties would satisfy the legitimate legislative wants as well as capital punishment. If they would, then the death penalty is unnecessary cruelty, and therefore unconstitutional. There are 6 purposes conceivably served by capital punishment: retribution, deterrence, prevention of repetitive criminal acts, encouragement of guilty pleas and confessions, eugenics, and economy. These are considered seriatim below. A. The concept of retribution is one of the most misunderstood in all of our criminal jurisprudence. The principal source of confusion derives from the fact that, in dealing with the concept, most people confuse the question, why do men in fact punish, with the question, what justifies men in punishing. Men may punish for any number of reasons, but the one reason that punishment is morally good or morally justifiable is that someone has broken the law. Thus, it can correctly be said that breaking the law is the sine qua non of punishment, or, in other words, that we only tolerate punishment as it is imposed on one who deviates from the norm established by the criminal law. The fact that the state may seek retribution against those who have broken its laws does not mean that retribution may then become the state's sole end in punishing. Our jurisprudence has always accepted deterrence in general, deterrence of individual recidivism, isolation of dangerous persons, and rehabilitation as proper goals of punishment. Retaliation, vengeance, and retribution have been roundly condemned as intolerable aspirations for a government in a free society. Punishment as retribution has been condemned by scholars for centuries, and the Eighth Amendment itself was adopted to prevent punishment from becoming synonymous with vengeance. In Weems v. United States, the court, in the course of holding that Weems' punishment violated the Eighth Amendment, contrasted it with penalties provided for other offenses, and concluded, "This contrast shows more than different exercises of legislative judgment. It is greater than that. It condemns the sentence in this case as cruel and unusual. It exhibits a difference between unrestrained power and that which is exercised under the spirit of constitutional limitations formed to establish justice. The state thereby suffers nothing and loses no power. The purpose of punishment is fulfilled, crime is repressed by penalties or of just, not tormenting severity, its repetition is prevented, and hope is given for the reformation of the criminal." It is plain that the view of the Weems court was that punishment for the sake of retribution was not permissible under the Eighth Amendment. This is the only view that the court could have taken if the cruel and unusual language were to be given any meaning. Retribution surely underlies the imposition of some punishment on one who commits a criminal act. But the fact that some punishment may be imposed does not mean that any punishment is permissible. If retribution alone could serve as a justification for any particular penalty, then all penalties selected by the legislature would, by definition, be acceptable means for designating society's moral approbation of a particular act. The cruel and unusual language would thus be read out of the Constitution, and the fear of Patrick Henry and the other founding fathers would become realities. To preserve the integrity of the Eighth Amendment, the court has consistently denigrated retribution as a permissible goal of punishment. It is undoubtedly correct that there is a demand for vengeance on the part of many persons in a community against one who is convicted of a particularly offensive act. At times, a cry is heard that morality requires vengeance to evidence society's abhorrence of the act. But the Eighth Amendment is our insulation from our baser selves. The cruel and unusual language limits the avenues through which vengeance can be channeled. Were this not so, the language would be empty, and a return to the rack and other tortures would be possible in a given case. Mr. Justice Story wrote that the Eighth Amendment's limitation on punishment would seem to be wholly unnecessary in a free government, since it is scarcely possible that any department of such a government should authorize or justify such atrocious conduct. I would reach an opposite conclusion, that only in a free society would men recognize their inherent weaknesses and seek to compensate for them by means of a constitution. The history of the Eighth Amendment supports only the conclusion that retribution for its own sake is improper. B. The most hotly contested issue regarding capital punishment is whether it is better than life imprisonment as a deterrent to crime. While the contrary position has been argued, it is my firm opinion that the death penalty is a more severe sanction than life imprisonment. Admittedly, there are some persons who would rather die than languish in prison for a lifetime. But whether or not they should be able to choose death as an alternative is a far different question from that presented here, i.e., whether the state can impose death as a punishment. Death is irrevocable. Life imprisonment is not. Death, of course, makes rehabilitation impossible. Life imprisonment does not. In short, death has always been viewed as the ultimate sanction, and it seems perfectly reasonable to continue to view it as such. It must be kept in mind, then, that the question to be considered is not simply whether capital punishment is a deterrent, but whether it is a better deterrent than life imprisonment. There is no more complex problem than determining the deterrent efficacy of the death penalty. Capital punishment has obviously failed as a deterrent when a murder is committed. We can number its failures, but we cannot number its successes. No one can ever know how many people have refrained from murder because of the fear of being hanged. This is the nub of the problem, and it is exacerbated by the paucity of useful data. The United States is more fortunate than most countries, however, in that it has what are generally considered to be the world's most reliable statistics. The two strongest arguments in favor of capital punishment as a deterrent are both logical hypotheses devoid of evidentiary support, but persuasive nonetheless. The first proposition was best stated by Sir James Stephen in 1864. No other punishment deters men so effectually from committing crimes as the punishment of death. This is one of those propositions which it is difficult to prove simply because they are in themselves more obvious than any proof can make them. It is possible to display ingenuity in arguing against it, but that is all. The whole experience of mankind is in the other direction. The threat of instant death is the one to which resort has always been made when there was an absolute necessity for producing some result. No one goes to certain inevitable death except by compulsion. Put the matter in the other way. Was there ever yet a criminal who, when sentenced to death and brought out to die, would refuse the offer of a commutation of his sentence for the severest secondary punishment? Surely not. Why is this? It can only be because all that a man has will he give for his life. In any secondary punishment, however terrible, there is hope, but death is death. Its terrors cannot be described more forcibly. This hypothesis relates to the use of capital punishment as a deterrent for any crime. The second proposition is that if life imprisonment is the maximum penalty for a crime such as murder, an offender who is serving a life sentence cannot then be deterred from murdering a fellow inmate or a prison officer. This hypothesis advocates a limited deterrent effect under particular circumstances. Abolitionists attempt to disprove these hypotheses by amassing statistical evidence to demonstrate that there is no correlation between criminal activity and the existence or non-existence of a capital sanction. Almost all of the evidence involves the crime of murder, since murder is punishable by death in more jurisdictions than are other offenses, and almost 90% of all executions since 1930 have been pursuant to murder convictions. Thorsten Selin, one of the leading authorities on capital punishment, has urged that if the death penalty deters prospective murderers, the following hypotheses should be true. A. Murders should be less frequent in states that have the death penalty than in those that have abolished it, other factors being equal. Comparisons of this nature must be made among states that are as alike as possible in all other respects: character of population, social and economic condition, etc. In order not to introduce factors known to influence murder rates in a serious manner, but present in only one of these states. B. Murders should increase when the death penalty is abolished and should decline when it is restored. C. The deterrent effect should be greatest and should therefore affect murder rates most powerfully in those communities where the crime occurred and its consequences are most strongly brought home to the population. D. Law enforcement officers would be safer from murderous attacks in states that have the death penalty than in those without it. Selin's evidence indicates that not one of these propositions is true. This evidence has its problems, however. One is that there are no accurate figures for capital murders. There are only figures on homicides, and they, of course, include non-capital killings. A second problem is that certain murders undoubtedly are misinterpreted as accidental deaths or suicides, and there is no way of estimating the number of such undetected crimes. A third problem is that not all homicides are reported. Despite these difficulties, most authorities have assumed that the proportion of capital murders in a state's or nation's homicide statistics remains reasonably constant, and that the homicide statistics are therefore useful. Selin's statistics demonstrate that there is no correlation between the murder rate and the presence or absence of the capital sanction. He compares states that have similar characteristics and finds that, irrespective of their position on capital punishment, they have similar murder rates. In New England states, for example, there is no correlation between executions and homicide rates. The same is true for Midwestern states and for all others studied. Both the United Nations and Great Britain have acknowledged the validity of Selland's statistics. Selland also concludes that abolition and/or reintroduction of the death penalty had no effect on the homicide rates of the various states involved. This conclusion is borne out by others who have made similar inquiries and by the experience of other countries. Despite problems with the statistics, Selland's evidence has been relied upon in international studies of capital punishment. Statistics also show that the deterrent effect of capital punishment is no greater in those communities where executions take place than in other communities. In fact, there is some evidence that imposition of capital punishment may actually encourage crime rather than deter it. And while police and law enforcement officers are the strongest advocates of capital punishment, the evidence is overwhelming that police are no safer in communities that retain the sanction than in those that have abolished it. There is also a substantial body of data showing that the existence of the death penalty has virtually no effect on the homicide rate in prisons. Most of the persons sentenced to death are murderers, and murderers tend to be model prisoners. In sum, the only support for the theory that capital punishment is an effective deterrent is found in the hypotheses with which we began and the occasional stories about a specific individual being deterred from doing a contemplated criminal act. These claims of specific deterrence are often spurious, however, and may be more than counterbalanced by the tendency of capital punishment to incite certain crimes. The United Nations Committee that studied capital punishment found that it is generally agreed that between the retentionists and abolitionists, whatever their opinions about the validity of comparative studies of deterrence, that the data which now exist show no correlation between the existence of capital punishment and lower rates of capital crime. Despite the fact that abolitionists have not proved non-deterrence beyond a reasonable doubt, they have succeeded in showing by clear and convincing evidence that capital punishment is not necessary as a deterrent to crime in our society. That is all that they must do. We would shirk our judicial responsibilities if we failed to accept the presently existing statistics and demanded more proof. It may be that we now possess all the proof that anyone could ever hope to assemble on that subject. But even if further proof were to be forthcoming, I believe there is more than enough evidence presently available for a decision in this case. In 1793, William Bradford studied the utility of the death penalty in Pennsylvania and found that it probably had no deterrent effect, but that more evidence was needed. Edward Livingston reached a similar conclusion with respect to deterrence in 1833 upon completion of his study for Louisiana. Virtually every study that has since been undertaken has reached the same result. In light of the massive amount of evidence before us, I see no alternative but to conclude that capital punishment cannot be justified on the basis of its deterrent effect. C. Much of what must be said about the death penalty as a device to prevent recidivism is obvious. If a murderer is executed, he cannot possibly commit another offense. The fact is, however, that murderers are extremely unlikely to commit other crimes either in prison or upon their release. For the most part, they are first offenders, and when released from prison, they are known to become model citizens. Furthermore, most persons who commit capital crimes are not executed. With respect to those who are sentenced to die, it is critical to note that the jury is never asked to determine whether they are likely to be recidivists. In light of these facts, if capital punishment were justified purely on the basis of preventing recidivism, it would have to be considered to be excessive. No general need to obliterate all capital offenders could have been demonstrated, nor any specific need in individual cases. No general need to obliterate all capital offenders could have been demonstrated, nor any specific need in individual cases. D. The three final purposes which may underlie utilization of a capital sanction, encouraging guilty pleas and confessions, eugenics, and reducing state expenditures, may be dealt with quickly. If the death penalty is used to encourage guilty pleas, and thus to deter suspects from exercising their rights under the Sixth Amendment to jury trials, it is unconstitutional. Its elimination would do little to impair the state's bargaining position in criminal cases, since life imprisonment remains a severe sanction which can be used as leverage for bargaining for pleas or confessions in exchange either for charges of lesser offenses or recommendations of leniency. Moreover, to the extent that capital punishment is used to encourage confessions and guilty pleas, it is not being used for punishment purposes. A state that justifies capital punishment on its utility as part of the conviction process could not profess to rely on capital punishment as a deterrent. Such a state's system would be structured with twin goals only: obtaining guilty pleas and confessions, and imposing imprisonment as the maximum sanction. Since life imprisonment is sufficient for bargaining purposes, the death penalty is excessive if used for the same purposes. In light of the previous discussion on deterrence, any suggestions concerning the eugenic benefits of capital punishment are obviously meritless. As I pointed out above, there is not even any attempt made to discover which capital offenders are likely to be recidivists, let alone which are positively incurable. No test or procedure presently exists by which incurables can be screened from those who would benefit from treatment. On the one hand, due process would seem to require that we have some procedure to demonstrate incurability before execution, and on the other hand, equal protection would then seemingly require that all incurables be executed. In addition, the cruel and unusual language would require that life imprisonment, treatment, and sterilization be inadequate for eugenic purposes. More importantly, this nation has never formally professed eugenic goals, and the history of the world does not look kindly on them. If eugenics is one of our purposes, then the legislatures should say so forthrightly and design procedures to serve this goal. Until such time, I can only conclude, as has virtually everyone else who has looked at the problem, that capital punishment cannot be defended on the basis of any eugenic purposes. As for the argument that it is cheaper to execute a capital offender than to imprison him for life, even assuming that such an argument, if true, would support a capital sanction, it is simply incorrect. A disproportionate amount of money spent on prisons is attributable to death row. Condemned men are not productive members of the prison community, although they could be, and executions are expensive. Appeals are often automatic, and courts admittedly spend more time with death cases. At trial, the selection of jurors is likely to become a costly, time-consuming problem in a capital case, and defense counsel will reasonably exhaust every possible means to save his client from execution, no matter how long the trial takes. During the period between conviction and execution, there are an inordinate number of collateral attacks on the conviction and attempts to obtain executive clemency, all of which exhaust the time, money, and effort of the state. There are also continual assertions that the condemned prisoner has gone insane. Because there is a formally established policy of not executing insane persons, great sums of money may be spent on detecting and curing mental illness in order to perform the execution. Since no one wants the responsibility for the execution, the condemned man is likely to be passed back and forth from doctors to custodial officials to courts like a ping pong ball. The entire process is very costly. When all is said and done, there can be no doubt that it costs more to execute a man than to keep him in prison for life. There is but one conclusion that can be drawn from all of this, i.e., the death penalty is an excessive and unnecessary punishment that violates the Eighth Amendment. The statistical evidence is not convincing beyond all doubt, but it is persuasive. It is not improper at this point to take judicial notice of the fact that for more than 200 years, men have labored to demonstrate that capital punishment serves no purpose, that life imprisonment could not serve equally well, and they have done so with great success. Little if any evidence has been adduced to prove the contrary. The point has now been reached at which deference to the legislatures is tantamount to abdication of our judicial roles as fact-finders, judges, and ultimate arbiters of the Constitution. We know that at some point the presumption of constitutionality accorded legislative acts gives way to a realistic assessment of those acts. This point comes when there is sufficient evidence available so that judges can determine not whether the legislature acted wisely, but whether it had any rational basis whatsoever for acting. We have this evidence before us now. There is no rational basis for concluding that capital punishment is not excessive. It therefore violates the Eighth Amendment. In addition, even if capital punishment is not excessive, it nonetheless violates the Eighth Amendment because it is morally unacceptable to the people of the United States at this time in their history. In judging whether or not a given penalty is morally acceptable, most courts have said that the punishment is valid unless it shocks the conscience and sense of justice of the people. Judge Frank once noted the problems inherent in the use of such a measuring stick. The court, before it reduces a sentence as cruel and unusual, must have reasonably good assurances that the sentence offends that the sentence offends the common conscience. And in any context, such a standard, the community's attitude, is usually an unknowable. It resembles a slithery shadow, since one can seldom learn at all accurately what the community or a majority actually feels. Even a carefully taken public opinion poll would be inconclusive in a case like this. While a public opinion poll obviously is of some assistance in indicating public acceptance or rejection of a specific penalty, its utility cannot be very great. This is because whether or not a punishment is cruel and unusual depends not on whether its mere mention shocks the conscience and sense of justice of the people, but on whether people who were fully informed as to the purposes of the penalty and its liabilities would find the penalty shocking, unjust, and unacceptable. In other words, the question with which we must deal is not whether a substantial proportion of American citizens would today, if polled, opine that capital punishment is barbarously cruel, but whether they would find it to be so in light of all information presently available. This is not to suggest that with respect to this test of unconstitutionality, people are required to act rationally. They are not. With respect to this judgment, a violation of the Eighth Amendment is totally dependent on the predictable, subjective, emotional reactions of informed citizens. It has often been noted that American citizens know almost nothing about capital punishment. Some of the conclusions arrived at in the preceding section and the supporting evidence would be critical to an informed judgment on the morality of the death penalty. For example, that the death penalty is no more effective a deterrent than life imprisonment, that convicted murderers are rarely executed, but are usually sentenced to a term in prison, that convicted murderers usually are model prisoners, and that they almost always become law-abiding citizens upon their release from prison, that the costs of executing a capital offender exceed the costs of imprisoning him for life, that while in prison a convict under sentence of death performs none of the useful functions that life prisoners perform, that no attempt is made in the sentencing process to ferret out likely recidivists for execution, and that the death penalty may actually stimulate criminal activity. This information would almost surely convince the average citizen that the death penalty was unwise, but a problem arises as to whether it would convince him that the penalty was morally reprehensible. This problem arises from the fact that the public's desire for retribution, even though this is a goal that the legislature cannot constitutionally pursue as its sole justification for capital punishment, might influence the citizenry's view of the morality of capital punishment. The solution to the problem lies in the fact that no one has ever seriously advanced retribution as a legitimate goal of our society. Defenses of capital punishment are always mounted on deterrent or other similar theories. This should not be surprising. It is the people of this country who have urged in the past that prisons rehabilitate as well as isolate offenders, and it is the people who have injected a sense of purpose in our penology. I cannot believe that at this stage in our history the American people would ever knowingly support purposeless vengeance. Thus, I believe that the great mass of citizens would conclude on the basis of the material already considered that the death penalty is immoral and therefore unconstitutional. But if this information needs supplementing, I believe that the following facts would serve to convince even the most hesitant of citizens to condemn death as a sanction. Capital punishment is imposed discriminatorily against certain identifiable classes of people. There is evidence that innocent people have been executed before their innocence can be proved, and the death penalty wreaks havoc with our entire criminal justice system. Each of these facts is considered briefly below. Regarding discrimination, it has been said that it is usually the poor, the illiterate, the underprivileged, the member of a minority group, the man who, because he is without means and is defended by a court-appointed attorney, who becomes society's sacrificial lamb. Indeed, a look at the bare statistics regarding executions is enough to betray much of the discrimination. A total of 3,859 persons have been executed since 1930, of whom 1,751 were white and 2,066 were African American. Of the executions, 3,334 were for murder, 1,664 of the executed murderers were white, and 1,630 were African American. 455 persons, including 48 whites, and 405 African Americans were executed for rape. It is immediately apparent that African Americans were executed far more often than whites in proportion to their percentage of the population. Studies indicate that while the higher rate of execution among African Americans is partially due to a higher grade of crime, there is evidence of racial discrimination. Racial or other discriminations should not be surprising. In Magatha v. California, this court held that committing to the untrammeled discretion of the jury the power to pronounce life or death in capital cases is not offensive to anything in the Constitution. This was an open invitation to discrimination. There is also overwhelming evidence that the death penalty is employed against men and not women. Only 32 women have been executed since 1930, while 3,827 men have met a similar fate. It is difficult to understand why women have received such favorable treatment, since the purposes alleged served by capital punishment seemingly are equally applicable to both sexes. It also is evident that the burden of capital punishment falls upon the poor, the ignorant, and the underprivileged members of society. It is the poor and the members of minority groups who are least able to voice their complaints against capital punishment. Their impotence leaves them victims of a sanction that the wealthier, better represented, just as guilty person can escape. So long as the capital sanction is used only against the forlorn, easily forgotten members of society, legislatures are content to maintain the status quo, because change would draw attention to the problem and concern might develop. Ignorance is perpetuated and apathy soon becomes its mate, and we have today's situation. Just as Americans know little about who is executed and why, they are unaware of the potential dangers of executing an innocent man. Our beyond a reasonable doubt burden of proof in criminal cases is intended to protect the innocent, but we know it is not foolproof. Various studies have shown that people whose innocence is later convincingly established are convicted and sentenced to death. Proving one's innocence after a jury finding of guilt is almost impossible. While reviewing courts are willing to entertain all kinds of collateral attacks where a sentence of death is involved, they very rarely dispute the jury's interpretation of the evidence. This is, perhaps, as it should be. But if an innocent man has been found guilty, he must then depend on the good faith of the prosecutor's office to help him establish his innocence. There is evidence, however, that prosecutors do not welcome the idea of having convictions, which they labored hard to secure, overturned, and that their cooperation is highly unlikely. No matter how careful courts are, the possibility of perjured testimony, mistaken honest testimony, and human error remain all too real. We have no way of judging how many innocent persons have been executed, but we can be certain that there were some. Whether there were many is an open question made difficult by the loss of those who are most knowledgeable about the crime for which they were convicted. Surely there will be more as long as capital punishment remains part of our penal law. While it is difficult to ascertain with certainty the degree to which the death penalty is discriminatorily imposed or the number of innocent persons sentenced to die, there is one conclusion about the penalty that is universally accepted, i.e., it tends to distort the course of the criminal law. As Mr. Justice Frankfurter said, I am strongly against capital punishment. When life is at hazard in a trial, it sensationalizes the whole thing almost unwittingly. The effect on juries, the bar, the public, the judiciary I regard as very bad. I think scientifically the claim of deterrence is not worth much. Whatever proof there may be, in my judgment, does not outweigh the social loss due to the inherent sensationalism of a trial for life. The deleterious effects of the death penalty are also felt otherwise than at trial. For example, its very existence inevitably sabotages a social or institutional program of reformation. In short, the presence of the death penalty as the keystone of our penal system bedevils the administration of criminal justice all the way down the line and is the stumbling block in the path of general reform and of the treatment of crime and criminals. Assuming knowledge of all the facts presently available regarding capital punishment, the average citizen would, in my opinion, find it shocking to his conscience and sense of justice. For this reason alone, capital punishment cannot stand. To arrive at the conclusion that the death penalty violates the Eighth Amendment, we have to engage in a long and tedious journey. The amount of information that we have assembled and sorted is enormous. Yet I firmly believe that we have not deviated in the slightest from the principles with which we began. At a time in our history when the streets of the nation's cities inspire fear and despair rather than pride and hope, it is difficult to maintain objectivity and concern for our fellow citizens. But the measure of a country's greatness is its ability to retain compassion in time of crisis. No nation in the recorded history of man has a greater tradition of revering justice and fair treatment for all its citizens in times of turmoil, confusion, and tension than ours. This is a country which stands tallest in troubled times, a country that clings to fundamental principles, cherishes its constitutional heritage, and rejects simple solutions that compromise the values that lie at the roots of our democratic system. In striking down capital punishment, this court does not malign our system of government. On the contrary, it pays homage to it. Only in a free society could right triumph in difficult times, and could civilization record its magnificent advancement. In recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. We achieve a major milestone in the long road up from barbarism, and join the approximately 70 other jurisdictions in the world which celebrate their regard for civilization and humanity by shunning capital punishment. I concur in the judgments of the court. And this is just the appendix. Mr. Chief Justice Berger, with whom Mr. Justice Blackmun, Justice Powell, and Justice Rehnquist joined dissenting. At the outset, it is important to note that only two members of the court, Mr. Justice Brennan and Mr. Justice Marshall, have concluded that the Eighth Amendment prohibits capital punishment for all crimes and under all circumstances. Mr. Justice Douglas has also determined that the death penalty contravenes the Eighth Amendment, although I do not read his opinion as necessarily requiring final abolition of the penalty. For the reasons set forth in parts 1 through 4 of this opinion, I conclude that the constitutional prohibition against cruel and unusual punishment cannot be construed to bar the imposition of the punishment of death. Mr. Justice Stewart and Mr. Justice White have concluded that petitioners' death sentences must be set aside because prevailing sentencing practices do not comply with the Eighth Amendment. For the reasons set forth in Part 5 of this opinion, I believe this approach fundamentally misconceives the nature of the Eighth Amendment's guarantee and flies directly in the face of controlling authority of extremely recent vintage. If we were possessed of legislative power, I would either join with Mr. Justice Brennan and Mr. Justice Marshall, or at the very least, restrict the use of capital punishment to a small category of the most heinous crimes. Our constitutional inquiry, however, must be divorced from personal feelings as to the morality and efficacy of the death penalty, and be confined to the meaning and applicability of the uncertain language of the Eighth Amendment. There is no novelty in being called upon to interpret a constitutional provision that is less than self-defining, but of all our fundamental guarantees, the ban on cruel and unusual punishments is one of the most difficult to translate into judicially manageable terms. The widely divergent views of the amendment expressed in today's opinions reveal the haze that surrounds this constitutional command. Yet it is essential to our role as a court that we not seize upon the enigmatic character of the guarantee as an invitation to enact our personal predilections into law. Although the Eighth Amendment literally reads as prohibiting only those punishments that are both cruel and unusual, history compels the conclusion that the Constitution prohibits all punishments of extreme and barbarous cruelty, regardless of how frequently or infrequently imposed. The most persuasive analysis of Parliament's adoption of the English Bill of Rights of 1689, the unquestioned source of the Eighth Amendment wording, suggests that the prohibition against cruel and unusual punishments was included therein out of aversion to severe punishments not legally authorized and not within the jurisdiction of the courts to impose. To the extent that the term unusual had any importance in the English version, it was apparently intended as a reference to illegal punishments. From every indication, the framers of the Eighth Amendment intended to give the phrase a meaning far different from that of its English precursor. The records of the debates in several of the state conventions called to ratify the 1789 draft Constitution, submitted prior to the addition of the Bill of Rights, show that the framers' exclusive concern was the absence of any ban on tortures. The later inclusion of the Cruel and Unusual Punishments Clause was in response to these objections. There was no discussion of the interrelationship of the terms cruel and unusual, and there is nothing in the debates supporting the inference that the Founding Fathers would have been receptive to tortuous or excessively cruel punishments, even if usual in character or authorized by law. The cases decided under the Eighth Amendment are consistent with the tone of the ratifying debates. In Wilkerson v. Utah, this court held that execution by shooting was not a prohibited mode of carrying out a sentence of death. Speaking to the meaning of the Cruel and Unusual Punishments Clause, the court said, "It is safe to affirm that punishment of torture and all others in the same line of unnecessary cruelty are forbidden by that amendment to the Constitution." The court made no reference to the role of the term unusual in the constitutional guarantee. In the case of Kemmler, the court held the Eighth Amendment inapplicable to the states and added the following dictum: so that if the punishment prescribed of an offense against the laws of the state were manifestly cruel and unusual, as burning at the stake, crucifixion, breaking on the wheel, or the like, it would be the duty of the courts to adjudge such penalties to be within prohibition of the New York Constitution, and we think this equally true of the Eighth Amendment in its application to Congress. Punishments are cruel when they involve torture or a lingering death, but the punishment of death is not cruel, within the meaning of that word as used in the Constitution. It implies there's something inhuman and barbarous, something more than the mere extinguishment of life. This language again reveals an exclusive concern with extreme cruelty. The court made passing reference to the finding of the New York courts that electrocution was an unusual punishment, but it saw no need to discuss the significance of that term as used in the Eighth Amendment. Opinions in subsequent cases also speak of extreme cruelty as though that were the sum of substances as Opinions in subsequent cases also speak of extreme cruelty as though that were the sum and substance of the constitutional prohibition. As summarized by Chief Justice Warren in the plurality opinion in Trott v. Dulles, whether the word unusual has any qualitative meaning different from cruel is not clear. On the few occasions this court has had to consider the meaning of the phrase, precise distinctions between cruelty and unusualness do not seem to have been drawn. These cases indicate that the court simply examines the particular punishment involved in light of the basic prohibition against inhuman treatment, without regard to any subtleties of meaning that might be latent in the word unusual. I do not suggest that the presence of the word unusual in the Eighth Amendment is merely a vestigial, having no relevance to the constitutionality of any punishment that might be devised. But whereas here, we considered a punishment well known to history, and clearly authorized by legislative enactments, it disregards the history of the Eighth Amendment and all of the judicial comment that has followed to rely on the term unusual as affecting the outcome of these cases. Instead, I view these cases as turning on the single question whether capital punishment is cruel in the constitutional sense. The term unusual cannot be read as limiting the ban on cruel punishments, or as somehow expanding the meaning of the term cruel. For this reason, I am unpersuaded by the facial argument that since capital punishment has always been cruel in the everyday sense of the word, and has become unusual due to decreased use, it is therefore now cruel and unusual. Counsel for petitioners properly concede that capital punishment was not impermissibly cruel at the time of the adoption of the Eighth Amendment. Not only do the records of the debates indicate that the Founding Fathers were limited in their concern to the prevention of torture, but it is also clear from the language of the Constitution itself that there was no thought whatever of the elimination of capital punishment. The opening sentence of the Fifth Amendment is a guarantee that the death penalty not be imposed unless on the presentment or indictment of a grand jury. The double jeopardy clause of the Fifth Amendment is a prohibition against being twice put in jeopardy of life for the same offense. Similarly, the due process clause commands due process of law before an accused can be deprived of life, liberty, or property. Thus, the explicit language of the Constitution affirmatively acknowledges the legal power to impose capital punishment. It does not expressly or by implication acknowledge the legal power to impose any of the various punishments that have been banned as cruel since 1791. Since the Eighth Amendment was adopted on the same day in 1791 as the Fifth Amendment, it hardly needs more to establish that the death penalty was not cruel in the constitutional sense at the time. In the 181 years since the enactment of the Eighth Amendment, not a single decision of this court has cast the slightest shadow of a doubt on the constitutionality of capital punishment. In rejecting Eighth Amendment attacks on particular modes of execution, the court has more than once implicitly denied that capital punishment is impermissibly cruel in the constitutional sense. It is only 14 years since Mr. Chief Justice Warren, speaking for 4 members of the court, stated without equivocation, whatever the arguments may be against capital punishment, both on moral grounds and in terms of accomplishing the purposes of punishment, and they are forceful, the death penalty has been employed throughout our history, and in a day when it is still widely accepted, it cannot be said to violate the constitutionality. It cannot be said to violate the constitutional concept of cruelty. It is only 1 year since Mr. Justice Black made his feelings clear on the constitutional issue. The Eighth Amendment forbids cruel and unusual punishments. In my view, these words cannot be read to outlaw capital punishment because that penalty was in common use and authorized by law here and in the countries from which our ancestors came at the time the amendment was adopted. It is inconceivable to me that the framers intended to end capital punishment by the amendment. By limiting its grants of certiorari, the court has refused even to hear argument on the Eighth Amendment claim on 2 occasions in the last 4 years. In these cases, the court confined its attention to the procedural aspects of capital trials, it being implicit that the punishment itself could be constitutionally imposed. Nonetheless, the court has now been asked to hold that a punishment clearly permissible under the Constitution at the time of its adoption and accepted as such by every member of the court until today is suddenly so cruel as to become incompatible with the Eighth Amendment. Before recognizing such an instant evolution in the law, it seems fair to ask what factors have changed that capital punishment should now be cruel in the constitutional sense as it has not been in the past. It is apparent that there has been no change of constitutional significance in the nature of the punishment itself. 20th century modes of execution surely involve no greater physical suffering than the means employed at the time of the Eighth Amendment's adoption, and although a man awaiting execution must inevitably experience extraordinary mental anguish, no one suggests that this anguish is materially different from that experienced by condemned men in 1791, even though protracted appellate review processes have greatly increased the waiting time on death row. To be sure, the ordeal of the condemned man may be thought cruel in the sense that all suffering is thought cruel. But if the Constitution proscribed every punishment producing severe emotional stress, then capital punishment would clearly have been impermissible in 1791. However, the inquiry cannot end here. For reasons unrelated to any change in intrinsic cruelty, the Eighth Amendment prohibition cannot fairly be limited to those punishments, though excessively cruel and barbarous at the time of the adoption of the Eighth Amendment. A punishment is inordinately cruel in the sense we must deal with it in these cases, chiefly as perceived by the society so characterizing it. The standard of extreme cruelty is not merely as descriptive, but necessarily embodies a moral judgment. The standard itself remains the same, but its applicability must change as the basic mores of society change. This notion is not new to Eighth Amendment adjudication. In Weems v. United States, the court referred with apparent approval to the opinion of the commentators that the clause of the Constitution may be therefore progressive and is not fastened to the obsolete, but may acquire meaning as public opinion becomes enlightened by a humane justice. Mr. Chief Justice Warren, writing the plurality opinion in Trop v. Dulles, the amendment must draw its meaning from the evolving standards of decency that mark the progress of a maturing society. Nevertheless, the court up to now has never actually held that a punishment has become impermissibly cruel due to a shift in the weight of accepted social values, nor has the court suggested judicially manageable criteria for measuring such a shift in moral consensus. The court's quiescence in this area can be attributed to the fact that in a democratic society, legislatures, not courts, are constituted to respond to the will and consequently the moral values of the people. For this reason, early commentators suggested that the cruel and unusual punishments clause was an unnecessary constitutional provision. As acknowledged in the principal brief for petitioners, both in constitutional contemplation and in fact, it is the legislature, not the court, which responds to public opinion and immediately reflects the society's standards of decency. Accordingly, punishments such as branding and the cutting off of ears, which were commonplace at the time of the adoption of the Constitution, passed from the penal scene without judicial intervention because they became basically offensive to the people and the legislature responded to the sentiment. Beyond any doubt, if we were today called upon to review such punishments, we would find them excessively cruel because we could say with complete assurance that contemporary society universally rejects such bizarre penalties. However, this speculation on the court's probable reaction to such punishments is not of itself significant. The critical fact is that this court has never had to hold that a mode of punishment authorized by a domestic legislature was so cruel as to be fundamentally at odds with our basic notions of decency. Judicial findings of impermissible cruelty have been limited, for the most part, to offensive punishments devised without specific authority by prison officials, not by legislatures. The paucity of judicial decisions invalidating legislatively prescribed punishments is powerful evidence that in this country, legislatures have in fact been responsive, albeit belatedly at times, to change in social attitudes and moral values. I do not suggest that the validity of legislatively authorized punishments presents no justiciable issue under the Eighth Amendment, but rather that the primacy of the legislative role narrowly confines the scope of judicial inquiry. Whether or not provable, or whether or not true at all times, in a democracy, the legislative judgment is presumed to embody the basic standards of decency prevailing in the society. This presumption can only be negated by unambiguous and compelling evidence of legislative default. There is no obvious indications that capital punishment offends the conscience of society to such a degree that our traditional deference to the legislative judgment must be abandoned. It is not a punishment such as burning at the stake that everyone would ineffably find to be repugnant to all civilized standards, nor is it a punishment so roundly condemned that only a few aberrant legislatures have retained it on the statute books. Capital punishment is authorized by statute in 40 states, the District of Columbia, and in the federal courts for the commission of certain crimes. On 4 occasions in the last 11 years, Congress has added to the list of federal crimes punishable by death. In looking for reliable indicia of contemporary attitude, none more trustworthy has been advanced. One conceivable source of evidence that legislatures have abdicated their essentially barometric role with respect to community values would be public opinion polls, of which there have been many in the past decade, addressed to the question of capital punishment, without assessing the reliability of such polls or intimating that any judicial reliance could ever be placed on them. It need only be noted that the reported results have shown nothing approximating a universal condemnation of capital punishment that might lead us to suspect that the legislatures in general have lost touch with current social values. Counsel for petitioners rely on a different body of empirical evidence. They argue, in effect, that the number of cases in which the death penalty is imposed, as compared with the number of cases in which it is statutorily available, reflects a general revulsion toward the penalty that would lead to its repeal if only it were more generally and widely enforced. It cannot be gainsaid that by the choice of juries and sometimes judges, the death penalty is imposed in far fewer than half the cases in which it is available. To go further and characterize the rate of imposition as freakishly rare, as petitioners insist, is unwarranted hyperbole, and regardless of its characterization, the rate of imposition does not impel the conclusion that capital punishment is now regarded as intolerably cruel or uncivilized. It is argued that in those capital cases where juries have recommended mercy, they have given expression to civilized values and effectively renounced the legislative authorization for capital punishment. At the same time, it is argued that where juries have made the awesome decision to send men to their deaths, they have acted arbitrarily and without sensitivity to prevailing standards of decency. This explanation for the infrequency of imposition of capital punishment is unsupported by known facts and is inconsistent in principle with everything this court has ever said about the functioning of juries in capital cases. In McGautha v. California, decided only 1 year ago, the court held that there was no mandate in the Due Process Clause of the 14th Amendment that juries be given instructions as to when the death penalty should be imposed. After reviewing the autonomy that juries have traditionally exercised in capital cases and noting the practical difficulties of framing manageable instructions, this court concluded that judicially articulated standards were not needed to ensure a responsible decision as to penalty. Nothing in McGautha licenses capital juries to act arbitrarily or assume that they have so acted in the past. On the contrary, the assumption underlying the McGautha ruling is that juries will act with due regard for the consequences of their decision. The responsibility of juries deciding capital cases in our system of justice was nowhere better described than in Witherspoon v. Illinois. A jury must choose between life imprisonment and capital punishment, can do little more, and must do nothing less than express the conscience of the community on the ultimate question of life or death. and one of the most important functions any jury can perform in making such a selection is to maintain a link between contemporary community values and the penal system, a link without which the determination of punishment could hardly reflect the evolving standards of decency that mark the progress of a maturing society. The selectivity of juries in imposing the punishment of death is properly viewed as a refinement on, rather than a repudiation of, the statutory authorization for that penalty. Legislatures prescribe the categories of crimes for which the death penalty should be available and acting as the conscience of the community. Juries are entrusted to determine in individual cases that the ultimate punishment is warranted. Juries are undoubtedly influenced in this judgment by myriad factors: the motive or lack of motive of the perpetrator, the degree of injury or suffering of the victim or victims, and the degree of brutality in the commission of the crime would seem to be prominent among these factors. Given the general awareness that death is no longer a routine punishment for the crimes for which it is made available, it is hardly surprising that juries have been increasingly meticulous in their imposition of the penalty. But to assume for the mere fact of relative infrequency that only a random assortment of pariahs are sentenced to death is to cast grave doubt on the basic integrity of our jury system. It would, of course, be unrealistic to assume that juries have been perfectly consistent in choosing the cases where the death penalty is to be imposed, for no human institution performs with perfect consistency. There are doubtless prisoners on death row who would not be there had they been tried before a different jury or in a different state. In this sense, their fate has been controlled by a fortuitous circumstance. However, this element of fortuity does not stand as an indicator either of the general functioning of juries in capital cases or of the integrity of jury decisions in individual cases. There is no empirical basis for concluding that juries have generally failed to discharge in good faith the responsibility described in Witherspoon, that of choosing between life and death in individual cases according to the dictates of community values. The rate of imposition of death sentences falls far short of providing the requisite unambiguous evidence that the legislatures of 40 states and the Congress have turned their backs on current or evolving standards of decency in continuing to make the death penalty available. For if selective imposition evidences a rejection of capital punishment in those cases where it is not imposed, it surely evidences a correlative affirmation of the penalty in those cases where it is imposed. Absent some clear indication that the continued imposition of the death penalty on a selective basis is violative of prevailing standards of civilized conduct, the Eighth Amendment cannot be said to interdict its use. In two of these cases, we have been asked to rule on the narrower question whether capital punishment offends the Eighth Amendment when imposed as the punishment for the crime of forcible rape. It is true that the death penalty is authorized for rape in fewer states than it is for murder, and that even in those states it is applied more sparingly for rape than for murder. But for the reasons aptly brought out in the opinion of Mr. Justice Powell, I do not believe these differences can be elevated to the level of an Eighth Amendment distinction. This blunt constitutional command cannot be sharpened to carve neat distinctions corresponding to the categories of crimes defined by the legislatures. Capital punishment has also been attacked as violative of the Eighth Amendment on the ground that it is not needed to achieve legitimate penal aims and is thus unnecessarily cruel. As a pure policy matter, this approach has much to recommend it, but it seeks to give a dimension to the Eighth Amendment that it was never intended to have and promotes a line of inquiry that this court has never before pursued. The Eighth Amendment, as I have noted, was included in the Bill of Rights to guard against the use of torturous and inhuman punishments, not those of limited efficacy. One of the few to speak out against the adoption of the Eighth Amendment asserted that it is often necessary to use cruel punishments to deter crimes. But among those favoring the amendment, no sentiment was expressed in that a punishment of extreme cruelty could ever be justified by expediency. The dominant theme of the Eighth Amendment debates was that the ends of the criminal laws cannot justify the use of measures of extreme cruelty to achieve them. The apparent seed of the unnecessary cruelty argument is the following language, quoted earlier, found in Wilkerson v. Utah. Difficulty would attend the effort to define with exactness the extent of the constitutional provision which provides that cruel and unusual punishments shall not be inflicted, but it is safe to affirm that punishments of torture and all others in the same line of unnecessary cruelty are forbidden by that amendment to the Constitution. To lift the italicized phrase from the context of the Wilkerson opinion and now view it as a mandate for assessing the value of punishments in achieving the aims of penology is a gross distortion. Nowhere are such aims even mentioned in the Wilkerson opinion. The only fair reading of this phrase is that punishments similar to torture in their extreme cruelty are prohibited by the Eighth Amendment. In Louisiana ex rel. Francis v. Resweber, the court made reference to the Eighth Amendment's prohibition against the infliction of unnecessary pain in carrying out an execution. The context makes abundantly clear that the court was disapproving the wanton infliction of physical pain and once again not advising pragmatic analysis of punishments approved by legislatures. Apart from these isolated uses of the word unnecessary, nothing in the cases suggests that it is for the courts to make a determination of the efficacy of punishments. The decision in Weems v. United States is not to the contrary. In Weems, the court held that for the crime of falsifying public documents, the punishment imposed under the Philippine Code of 15 years imprisonment at hard labor under shackles, followed by perpetual surveillance, loss of voting rights, loss of the right to hold public office, and loss of right to change domicile freely, was violative of the Eighth Amendment. The case is generally regarded as holding that a punishment may be excessively cruel within the meaning of the Eighth Amendment because it is grossly out of proportion to the severity of the crime. Some view of the decision of the court primarily as a reaction to the mode of the punishment itself. Under any characterization of the holding, it is readily apparent that the decision grew out of the court's overwhelming abhorrence of the imposition of the particular penalty for the particular crime. It was making an essentially moral judgment, not a dispassionate assessment of the need for the penalty. The court specifically disclaimed the right to assert a judgment against that of the legislature of the expediency of the laws, thus apart from the fact that the court in Weems concerned itself with the crime committed as well as the punishment imposed, the case marks no departure from the largely unarticulable standard of extreme cruelty. However intractable that standard may be, that is what the Eighth Amendment is all about. The constitutional provision is not addressed to social utility and does not command that enlightened principles of penology always be followed. By pursuing the necessity approach, it becomes even more apparent that it involves matters outside the purview of the Eighth Amendment. Two of the several aims of punishment are generally associated with capital punishment: retribution and deterrence. It is argued that retribution can be discounted because that, after all, is what the Eighth Amendment seeks to eliminate. There is no authority suggesting that the Eighth Amendment was intended to purge the law of its retributive elements, and the court has consistently assumed that retribution is a legitimate dimension of punishment of crimes. Furthermore, responsible legal thinkers of widely varying persuasions have debated the sociological and philosophical aspects of the retribution question for generations, neither side being able to convince the other. It would be reading a great deal into the Eighth Amendment to hold that the punishments authorized by legislatures cannot constitutionally reflect a retributive purpose. The less esoteric but no less controversial question is whether the death penalty acts as a superior deterrent. Those favoring abolition find no evidence that it does. Those favoring retention start from the intuitive notion that capital punishment should act as the most effective deterrent and note that there is no convincing evidence that it does not. Escape from this empirical stalemate is sought by placing the burden of proof on the states and concluding that they have failed to demonstrate that capital punishment is a more effective deterrent than life imprisonment. Numerous justifications have been advanced for shifting the burden, and they are not without their rhetorical appeal. However, these arguments are not descended from established constitutional principles, but are born of the urge to bypass an unresolved factual question. Comparative deterrence is not a matter that lends itself to precise measurement. To shift the burden to the states is to provide an illusory solution to an enormously complex problem. If it were proper to put the states to the test of demonstrating the deterrent value of capital punishment, we would just as well ask them to prove the need for life imprisonment or any other punishment. Yet I know of no convincing evidence that life imprisonment is a more effective deterrent than 20 years imprisonment, or even that a $10 parking ticket is a more effective deterrent than a $5 parking ticket. In fact, there are some who go so far as to challenge the notion that any punishment deters crime. If the states are unable to adduce convincing proof rebutting such assertions, does it then follow that all punishments are suspect as being cruel and unusual within the meaning of the Constitution? On the contrary, I submit that the questions raised by the necessity approach are beyond the pale of judicial inquiry under the Eighth Amendment. Today, the court has not ruled that capital punishment is per se violative of the Eighth Amendment, nor has it ruled that the punishment is barred for any particular class or classes of crimes. The substantially similar concurring opinions of Mr. Justice Stewart and Mr. Justice White, which are necessary to support the judgment setting aside petitioner's sentences, stop short of reaching the ultimate question. The actual scope of the court's ruling, which I take to be embodied in these concurring opinions, is not entirely clear. This much, however, seems apparent. If the legislatures are to continue to authorize capital punishment for some crimes, juries and judges can no longer be permitted to make the sentencing determination in the same manner they have in the past. This approach, not urged in oral arguments or briefs, misconceives the nature of the constitutional command against cruel and unusual punishments, disregards controlling case law, and demands a rigidity in capital cases which, if possible of achievement, cannot be regarded as a welcome change. Indeed, the contrary seems to be the case. As I have earlier stated, the Eighth Amendment forbids the imposition of punishments that are so cruel and inhumane as to violate society's standards of civilized conduct. The amendment does not prohibit all punishments the states are unable to prove necessary to deter or control crime. The amendment is not concerned with the process by which a state determines that a particular punishment is to be imposed in a particular case. And the amendment most assuredly does not speak to the power of legislatures to confer sentencing discretion on juries, rather than to fix all sentences by statute. The critical factor in the concurring opinions of both Mr. Justice Stewart and Mr. Justice White is the infrequency with which the penalty is imposed. This factor is taken not as evidence of society's abhorrence of capital punishment, the inference that petitioners would have the court draw, but as the earmark of a deteriorating system of sentencing. It is concluded that petitioners' sentences must be set aside, not because the punishment is impermissibly cruel, but because juries and judges have failed to exercise their sentencing discretion in acceptable fashion. To be sure, there is a recitation cast in Eighth Amendment terms. Petitioners' sentences are cruel because they exceed that which the legislatures have deemed necessary for all cases. Petitioner sentences are unusual because they exceed that which is imposed in most cases. This application of the words of the Eighth Amendment suggests that capital punishment can be made to satisfy Eighth Amendment values if its rate of imposition is somehow multiplied. It seemingly follows that the flexible sentencing system created by the legislatures and carried out by juries and judges has yielded more mercy than the Eighth Amendment can stand. The implications of this approach are mildly ironical. For example, by this measure of the Eighth Amendment, the elimination of death-qualified juries in Witherspoon v. Illinois can only be seen in retrospect as a setback to the evolving standards of decency that mark the progress of a maturing society. This novel formulation of Eighth Amendment principles, albeit necessary to satisfy the terms of our limited grant of certiorari, does not lie at the heart of these concurring opinions. The decisive grievance of the opinions not translated into Eighth Amendment terms is that the present system of discretionary sentencing in capital cases has failed to produce even-handed justice. The problem is not that too few have been sentenced to die, but that the selection process has followed no rational pattern. This claim of arbitrariness is not only lacking in empirical support, but also it manifestly fails to establish that the death penalty is a cruel and unusual punishment. The Eighth Amendment was included in the Bill of Rights to assure that certain types of punishments would never be imposed, not to channelize the sentencing process. The approach of these concurring opinions has no antecedent in the Eighth Amendment cases. It is essentially and exclusively a procedural due process argument. This ground of decision is plainly foreclosed as well as misplaced. Only 1 year ago in Magatha v. California, the court upheld the prevailing system of sentencing in capital cases. In light of history, experience, and the present limitations of human knowledge, we find it quite impossible to say committing to the untrammeled discretion of the jury the power to pronounce life or death in capital cases is offensive to anything in the Constitution. In reaching this decision, the court has the benefit of extensive briefing, full oral argument, and 6 months of careful deliberations. The court's labors are documented by 130 pages of opinions in the United States reports. All of the arguments and factual contentions accepted in the concurring opinions today were considered and rejected by the court 1 year ago. Magatha was an exceedingly difficult case, and reasonable men could fairly disagree as to the result. But the court entered its judgment, and if stare decisis means anything, that decision should be regarded as a controlling pronouncement of law. Although the court's decision in Magatha was technically confined to the dictates of the Due Process Clause of the 14th Amendment rather than the 8th Amendment, as made applicable to the states through the Due Process Clause of the 14th Amendment, it would be disingenuous to suggest that today's ruling has done anything less than overrule Magatha in the guise of an 8th Amendment adjudication. It may be thought appropriate to subordinate principles of stare decisis where the subject is as sensitive as capital punishment and the stakes are so high, but these external considerations were no less weighty last year. This pattern of decision-making will do little to inspire confidence in the stability of the law. While I would not undertake to make a definitive statement as to the parameters of the court's ruling, it is clear that if state legislatures and the Congress wish to maintain the availability of capital punishment, significant statutory changes will have to be made, since the two pivotal concurring opinions turn on the assumption that the punishment of death is not meted out in a random and unpredictable manner. Legislative bodies may seek to bring their laws into compliance with the court's ruling by providing standards for juries and judges to follow in determining the sentence in capital cases, or by more narrowly defining the crimes for which the penalty is to be imposed. If such standards can be devised, or the crimes more meticulously defined, the result cannot be detrimental. However, Mr. Justice Harlan's opinion for the court in Magatha convincingly demonstrates that all past efforts to identify before the fact the cases in which the penalty is to be imposed have been uniformly unsuccessful. One problem is that the factors which determine whether the sentence of death is the appropriate penalty in particular cases are too complex to be compressed within the limits of a simple formula. As the court stated in Magatha, the infinite variety of cases and facets to each case would make general standards either meaningless boilerplate or a statement of the obvious that no jury would need. But even assuming that suitable guidelines can be established, there is no assurance that sentencing patterns will change so long as juries are possessed of the power to determine the sentence or to bring in a verdict of guilt on a charge carrying a lesser sentence. Juries have not been inhibited in the exercise of these powers in the past. Thus, unless the court in Magatha misjudged the experience of history, there is little reason to believe that sentencing standards in any form will substantially alter the discretionary character of the prevailing system of sentencing in capital cases. That system may fall short of perfection, but it is yet to be shown that a different system would produce more satisfactory results. Real change could clearly be brought about if legislatures provide mandatory death sentences in such a way as to deny juries the opportunity to bring in a verdict on a lesser charge. Under such a system, the death sentence could only be avoided by a verdict of acquittal. If this is the only alternative that the legislatures can safely pursue under today's ruling, I would have preferred that the court opt for total abolition. It seems remarkable to me that with our basic trust in lay jurors as the keystone in our system of criminal justice, it should now be suggested that we take the most sensitive and important of all decisions away from them. I could more easily be persuaded that mandatory sentences of death, without the intervening and ameliorating impact of lay jurors, are so arbitrary and doctrinaire that they violate the Constitution. The very infrequency of death penalties imposed by jurors attests their cautious and discriminating reservation of that penalty for the most extreme cases. I had thought that nothing was clearer in history, as we noted in Magatha 1 year ago, than the American abhorrence of common law rule imposing a mandatory death sentence on all convicted murderers. As the concurring opinions of Mr. Justice Marshall shows, the 19th century movement away from mandatory death sentences marked an enlightened introduction of flexibility into the sentencing process. It recognized that individual culpability is not always measured by the category of the crime committed. This change in sentencing practice was greeted by the court as a humanizing development. I do not see how this history can be ignored and how it can be suggested that the Eighth Amendment demands the elimination of the most sensitive feature of the sentencing system. As a general matter, the evolution of penal concepts in this court has not been marked by great progress, nor have the results up to now been crowned with significant success. If anywhere in the whole spectrum of criminal justice fresh ideas deserve sober analysis, the sentencing and correctional area ranks high on the list. But it has been widely accepted that mandatory sentences for crimes do not best serve the ends of the criminal justice system. Now, after the long process of drawing away from the blind imposition of uniform sentences for every person convicted of a particular offense, we are confronted with an argument perhaps implying that only the legislatures may determine that a sentence of death is appropriate, without the intervening evaluation of jurors or judges. This approach threatens to turn back the progress of penal reform, which has moved until recently at too slow a rate to absorb significant setbacks. Since there is no majority of the court on the ultimate issue presented in these cases, the future of capital punishment in this country has been left in an uncertain limbo. Rather than providing a final and unambiguous answer on the basic constitutional question, the collective impact of the majority's ruling is to demand an undetermined measure of change from the various state legislatures and the Congress. While I cannot endorse the process of decision-making that has yielded today's result and the restraints that result imposes on legislative action, I am not altogether displeased that legislative bodies have been given the opportunity, and indeed unavoidable responsibility, to make a thorough reevaluation of the entire subject of capital punishment. If today's opinions demonstrate nothing else, they starkly show that this is an area where legislatures can act far more effectively than courts. The legislatures are free to eliminate capital punishment for specific crimes or to carve out limited exceptions to a general abolition of the penalty, without adherence to the conceptual strictures of the Eighth Amendment. The legislatures can and should make an assessment of the deterrent influence of capital punishment, both generally and as affecting the commission of specific types of crimes. If legislatures come to doubt the efficacy of capital punishment, they can abolish it, either completely or on a selective basis. If new evidence persuades them that they have acted unwisely, they can reverse their field and reinstate the penalty to the extent that it is thought warranted. An Eighth Amendment ruling by judges cannot be made with such flexibility or discriminating precision. The worldwide trend toward limiting the use of capital punishment, a phenomenon to which we have been urged to give great weight, hardly points the way to a judicial solution in this country under a written constitution. Rather, the change has generally come about through legislative action, often on a trial basis, and with the retention of the penalty for certain limited classes of crimes. Virtually nowhere has change been brought by so crude a tool as the Eighth Amendment. The complete and unconditional abolition of capital punishment in this country by judicial fiat would have undermined the careful progress of the legislative trend and foreclosed further inquiry on many as yet unanswered questions in this area. Quite apart from the limitations of the Eighth Amendment itself, the preference for legislative action is justified by the inability of the courts to participate in the debate at the level where the controversy is focused. The case against capital punishment is not the product of legal dialectic, but rests primarily on factual claims, the truth of which cannot be tested by conventional judicial processes. The 5 opinions in support of the judgments differ in many respects, but they share a willingness to make sweeping factual assertions unsupported by empirical data concerning the manner of imposition and effectiveness of capital punishment in this country. Legislatures will have the opportunity to make a more penetrating study of these claims with the familiar and effective tools available to them as they are not to us. The highest judicial duty is to recognize the limits on judicial power and to permit the democratic processes to deal with matters falling outside of those limits. The hydraulic pressures that Holmes spoke of as being generated by cases of great import have propelled the court to go beyond the limits of judicial power, while fortunately leaving some room for legislative judgment. And we'll stop right there for today, and I will be out with part 3 tomorrow. And as always, if there's any case you'd like me to read, just drop in the comments and I'm happy to take a look. Thank you.